A very warm welcome to the second episode in the series Agree to Disagree on behalf of Madhyam Youth Forum, which is the youth wing of Madhyam International Council for Conflict Resolution and Ambassadors of Mediation, to our esteemed guest of honor and all the participants, and of course the viewers. Just to reiterate, it's a new concept we are bringing for you. It's my proud privilege and honor to welcome once again all of you all to the first ever table debate series, Agree to Disagree. We have all been fortunate to have trained mediators, some of them being of international accreditation, discussing and sharing their views on the second topic for the debate: confidentiality is a myth in the mediation on the Ambassadors of Mediation WhatsApp group, for which we are extremely indebted as we learned a lot. And now, taking on from the discussions held, today we have invited four participants, all well established lawyers and trained mediators in their respective cities, to take the discussions further on in the form of a debate. Let's see what are their views on this topic. We are fortunate that we have Ms. Chitra Narayan, advocate, trained mediator with the Tamil Nadu Mediation and Conciliation Center. She is the author of Mediation Policy and Practice 2021, professor of practice, Daksh Fellowship, Sai University, trustee, Foundation for Comprehensive Dispute Resolution, FCDR, Chennai, as our guest of honor to guide the teams. As usual, we have two teams and four rounds. In the first round, each participant from each team will table their views in a few minutes. And in the second round, Ms. Narayan will ask a question each to the participants in random order. In the third round, the participants will again get an opportunity of rebuttal to the opposing team alternately, whereafter in the fourth round, our esteemed guest, Ms. Chitra Narayan, will give a short summarization of the debate. Let me introduce the teams to you. Team A for the motion comprises of Ms. Janvi Barua from Guwahati, Assam, Mr. M. Jagdish from Bengaluru, Karnataka. Team B against the motion comprises of Ms. Prerna Kohli from New Delhi and Mr. Prashant Chande from Mumbai, Maharashtra. So let's begin. Let's start with what Ms. Janvi Barua you have to say on this topic.
Well, confidentiality is a myth in mediation. So I strongly believe that it is a myth because when we talk about confidentiality, then usually we get to see that there are certain law mandates on disclosures. So in case of during the course of mediation, sometimes the mediator might come across some issues like where in the confidential session a POXO act might be violated somewhere. In that case, it is mandatory for the mediator, any person, to report. But here, since we are bound by confidentiality, we are not able to do that. But then it is again said that in the opening statement, the mediator can explain the process of confidentiality, keeping in mind that there is, so even explaining to the parties that there is an exception to it. But the moment we talk about an exception, the entire concept of confidentiality gets defeated because then the parties will lose faith in the process itself. So, and in another view of mine is that if the mediator is able to create a very, uh, you know, good environment where the trust building is done effectively, then the parties will definitely feel free to give their opinion, to let out their whatever agendas, whatever issues are there. They will speak up. They will themselves waive the confidentiality part because if the trust factor is built very strongly, then definitely I feel that the parties will not resort to the aspect of confidentiality. They will feel free to talk about their issues openly, even in a joint session. So definitely, again, I feel confidentiality is a myth. And another view of mine is that every mediator has a moral duty in ensuring fairness in the process. Suppose in a confidential session, the mediator comes to know of some facts which, if not disclosed to the other side, there could be a imbalance. There could be some unfairness on one of the parties. So then, how can you just cling on to this confidentiality aspect, keeping in mind the mediator's role to be you know to ensure the fairness of the process? So I don't think this is going to work, because if the moment we talk about confidentiality, we bind ourselves uh, to the fact that we cannot disclose anything. But the moment we talk about exceptions in confidentiality in the opening statement, again, then it all gets defeated. It is very contradictory.
Let's
So
see what your teammate, Mr. Jagdish, has to say on this topic. Thank you. Thank you,
Yes,
Janki.
I take it from where my teammate left. Confidentiality is a myth. Why? Because what is confidentiality? Let's understand. It is a state of keeping the things secret or private. And what is the myth? Myth is nothing but misconception or a false belief. So what you're saying is confidentiality means it's a misbelief that we think that it has in mediation. In my opinion, if you want to advance the matter, you have to compromise the confidentiality. If you keep your confidentiality to yourself, we cannot take the matter forward, in my opinion. So I have 3 points to say. One is transparency and confidentiality. Thomas D. Morger says confidentiality and transparency are mutually exclusive, but rather two sides of the same coin, which means we say in mediation we should have transparency. Having said that, you don't have a transparency, how can you have confidentiality? So we need to really look into it. So that is why we say it's a myth. As we all know, the world is becoming more and more transparent these days. So technology may not allow us to maintain confidentiality for a longer period. That is number one. Point number two is power imbalance. When we have two parties who come for a mediation and one person has got information which is more confidential, unless until it has been revealed in various ways, it could be by the way we project ourselves, the way we sit on the table, or it could be the way we behave before the mediator. That all shows the power imbalances. So to bring the power imbalances, sometimes we may have to play with the confidentiality. In my opinion, at that time, it becomes a myth. No more that as a mediator, to an extent, we might somewhere lose, is my personal opinion. And number three is
Um,
commercial matters.
Mr.
Yes,
Jagdish, I think we will have to pass on the baton to Team B, who's been waiting patiently.
sure.
So can we have
Okay, for
Reina?
sure.
Reina, what do you have to say?
Good evening, everyone, and thank you to the esteemed panel for having invited Mr. Prashant and me to speak on the topic in favor of confidentiality. What is a good definition of confidentiality? It's about maintaining privacy, respecting the wishes, and not to disclose information to another. The essence of confidentiality is trust, which is the heart of the mediation process. Without trust, there is no reason to continue. Works best if trust in the mediator, trust in the process, and the parties get a feeling of being reassured. It is very vitally important because it facilitates disclosure. It encourages parties to have an informed, open, candid exchange of ideas, frank discussions, opening constructive and creative dialogue, and enabling parties to discover ways to resolve their disputes, which is very independent of the judicial system. This element is unique and valuable for parties who wish to also preserve their relationships, their reputation, and work collaboratively for a mutual long term benefit. A decision made by both, which they could live with. If discussions with the mediator are not confidential, the mediator's role and the potential for resolution will be significantly diminished. The confidence in the process is all about and entails confidentiality. People will not disclose their needs, information, if they feel that it might be used against them. In fact, I think the fact that all participants sign an agreement to mediate, they understand the process, the mediator's role, and the confidentiality of the discussions. It is based on the premise that the confidential aspect of mediation will be preserved. The parties are made aware that there will be exchange between them, which will not be used to their detriment in court proceedings. The parties must understand that it's the trust in the mediator and who is also acting in their best interest. It is of paramount importance to parties because nothing would be divulged without their consent. They will discuss with their lawyers if need be about the quantum of information they would like to share and manage the information. In fact, a mediator could also use his discretion how he would like to reframe or rephrase the information which has been divulged to him. That requires developing a lot of skills, of course, but once you start the process, I think gathering information also helps in gathering the confidential information besides what the parties tell you.
Prerna ji, I think we will hear what your teammate Mr. Prashant has to say on this.
Good evening, everybody. I totally agree with my co-participant and taking it up further from there. How can you even say that confidentiality is not a reality and it is a myth? It's the very basis of mediation. In fact, we cannot even think of it as myth, and that is my first submission, because I still remember from the very first lectures which we attended in getting trained as a good mediator. One of the first pillars which were taught to us regarding mediation was that it is a confidential process. One of the first few steps which you are taught as a mediator in lectures is on making an opening statement. Now, when you make an opening statement, one of the first few things which you do speak to the parties is that please see that this entire process is confidential. You are free to say whatever you want to say over here. Nothing that you say over here will, of course, be repeated by me, and everything that you say is going to remain inside these particular four walls. One other concept which is explained to the parties in the very opening statement, and that being the very basic and the basis of mediation, is that we may reach a stage during the mediation process where there is an impasse, where the parties are not able to reach an agreement, and in which event we will be going into a private session which would be known as caucus. And in this private session, a mediator will be speaking individually to one of the parties instead of speaking to both the parties together. It is also explained in the opening statement to the parties that whatever is being spoken by the mediator to the party individually in the caucus will remain between the party and the mediator unless and until the mediator gets a go ahead or a green signal from the party disclosing the particular fact, that he can disclose that particular fact to the other side.
Thank you
So,
so much, sir. Thank you, Mr. Prashant.
thank
I think
you.
having heard all the participants, now I would like to invite Mr. Narayan, our guest, to please take over and please put forth all the questions to the participants.
Thank you, Pooja. You have all elaborated on various dimensions of confidentiality, uh, through this very provocative, position that is before the House. I want to ask Janvi this question. Janvi, there is information shared in the joint session. There are discussions in the joint session. There are discussions in private sessions. And then there are hopefully options generated, proposals exchanged. How would you define confidential information or discussions that need the benefit of or need the protection of confidentiality in all of this? Actually, the fact is that when a mediator is uh, explaining the ground rules or making the opening statement, and in the process, in the introduction part or the entire the beginning of the process, the mediator will make the parties feel at ease, so that because the parties want to arrive at a settlement, they want a resolution of their dispute. For that, I don't think they will want to keep anything hidden, because if they keep back any information, their purpose will be defeated. So I'm sure they will not ask for a confidential session where they will want to only confide with the mediator, and knowing very well that that information doesn't even reach the other side. They would, in order to uh, you know bring about a resolution of their dispute, they will definitely want to keep no stone unturned. They will want every aspect to be discussed openly, so that there is complete transparency in the process. Thank you, Janvi. My next question is to Prashantji.
Yes.
What are situations that you envisage where confidentiality has to take a back seat?
Uh, there are many such situations. For example, in family disputes, confidentiality would have to take a back seat. Let's say where domestic violence is involved, where there could be mergers and acquisitions of big corporates, etc., a lot of data sharing. So there are many such situations where confidentiality would have to take a backseat if necessary. For example, domestic violence is one issue which always troubles us mediators. And there have been many instances where during the mediation process, the mediator has come to know of some crime having been committed or some domestic violence having been committed. In family issues, there are cases where elderly parents, there may be certain mistreatment or ill treatment, which may borderline to some kind of a criminal offense. In such situations, the mediator is always in a dilemma as to what should be done and what should not be done. There have been many such instances.
Thank you, Prashantji.
Welcome.
Uh, my next question, I think, would be to Prerna. Prerna, given that um, you know, it is argued, in fact, that the advantage that mediation has, or the presence of a mediator in negotiations, the advantage it has over plain negotiation, where the two parties are negotiating between themselves, is the confidential information that is shared with the mediator, and the use that the mediator puts this information to guide parties towards settlement. Right. So, what would your view be on this use of confidential information, which is purposive, which is towards reaching a settlement. Prerna, I think you're muted.
Thank you, Chitra, for the question. And I would just like to elaborate on the confidentiality part of it. As a mediator who is a part of, basically it's all about the parties, right? The process of mediation. It's a party-centric process. So whatever is divulged to the mediator, I think in his discretion or her discretion, it is something where the party is speaking to them in complete confidence. And understanding the fact that there is certain amount of information which he may not or she may not wish to let go, the mediator would need to understand it in a broad spectrum. And thereafter, of course, if the parties have a counsel, there could be, and a counsel who's very proactive mediation, I think that could really assist in the process and help, maneuver around what information needs to be divulged. But of course, I completely appreciate that confidentiality is the core of mediation, and the parties should not at any time feel that there is something which they had not permitted or they were not willing to divulge has been conveyed by the mediator. So it's treading on very delicate, sensitive information. And for that very reason, if anybody wishes to convey as a mediator, or if the party is willing to convey it themselves, it needs to be reframed, and also keeping the fact that whatever is said does not really cause them to not have, break the faith in the process. So something which I think everybody will need to use their own discretion, their judgment, or storytelling, illustrative form, in some particular way where it is conveyed not directly if the parties are not too comfortable, but in a manner where they feel the comfort that yes, this is a way we would appreciate it being conveyed. And there are also certain times when the mediator is prohibited from even saying one word. So I think that needs to be really respected as a mediator. So I would look at it that way, wherein I would definitely like to sit down with the parties, understand their viewpoint, and whatever works for them would be the path I would take to convey.
So you're saying, Prerna, that it's layered confidentiality. And you're saying that it can be used purposively by the mediator, not by sharing the confidential information, but by conveying it in other ways.
Yeah.
Thanks. Thank you.
It just doesn't work if it's too direct. There could be misinterpretation of the message, and so somehow it has to be kind of taken into viewpoint. What is the party you're sitting with? Because no one size fits all. So yeah, thank you.
My last question to Jagdish.
Yeah.
Jagdish, confidentiality sits within a matrix of confidentiality, rules relating to confidentiality, rules relating to privilege, rules relating to admissibility of evidence, and disclosure. So, and three of the four sort of category of rules that I have mentioned go towards protecting confidentiality in a mediation or in settlement discussions. Why would you then say that it's mythical?
Yeah, that is why we are saying it's a myth, because in life we always say yes or no. We can't say maybe, because we have that maybe exceptions. That's why we say mediation still in a confidentiality is still a myth in mediation. You say there's a confidentiality, then you say because of these 1, 2, 3, 4 exceptions, I may tell it. Then how do I have belief that I can tell you? So because of this one reason, we have not seen mediation to the higher level compared to other things. If at all the laws made requirements where it should be done, it would be much more easier. First we say it's confidential, then we say exceptions. We don't say the exceptions in the opening statements. To most of them do not say. They say only in the later part when it's required, then we reveal it. So that is where the real problem is, that it is a myth. You cannot use the information for the advantage of the case. You tell exactly this is what it is so that I can reveal what is required. That will be my answer.
Thanks, Jagdish. So the position that Janvi and Jagdish have taken is that unless it's absolute, there is no confidentiality.
Thank you. Thank you so much, Chitraji. Thank you so much. So let's give the teams an opportunity of rebuttal, starting with you, Mr. Prashant. If there is any change of heart or you want to say anything to the opposite team, please, now is the time and opportunity.
There is no way that I am having any change of heart, and I am definitely going to give a few things back to my other team. It was sought to be argued by Mr. Jagdish that transparency and confidentiality are two sides of the same coin. You need to balance it out, and all those arguments, which I'll not repeat. See, the point is this, that when you are starting with mediation, the first thing that you are telling the parties is that please see everything that you say over here is confidential. How then do you afterwards go back, break the confidence, reveal certain things which have been told to you? In fact, you are actually going back on your word. You are breaking the trust which the party has on you. So there is no way that you can do it. You cannot go back on your word. You can no way break the trust, because the moment a party feels that its trust is being broken, it's going to back out and it's going to go out of the mediation process. So you have to keep one thing which you have said in the very beginning very clear. You have to keep it consistent and persistently keep saying that whatever you say is confident with me. Unless and until you give me the permission, I am not going to reveal it. That is the stand which you have to continuously keep taking, and that is the one thing which will ensure that the party has trust in you. Thank you.
Thank you. Thank you, Mr. Prashant. Yes, Mr. Jagdish, what do you have to say to that?
Yes. If you remember in Prashant Ji's, when he spoke, he said, family disputes, there cannot be confidentiality. That's what I meant. So you can't put that confidentiality in all the cases. There are a few exceptions. You yourself say in family disputes, they cannot have the confidentiality. And also, even our Prerna ji also said that, to arrive at a settlement, we need to divulge. But how do we do that? That we do as a mediator. We use the art of communication to use the divulge the confidential information. We all trained, we know how to say it, but we say it, not that we don't say it. So that with one intention saying that let's close the matter. But as a mediator, we should not. We're only facilitator. Theoretically, we say we should be detached. Having said that, practically, it is very, very hard to be detached. We always get attached because we know both the parties, we heard both the parties. We also somewhere say in our own body language or emotions, the way we say, can we give this information? Can we get this balanced out? Can we close this matter? That's where we say it is a myth.
Thank you, Mr. Jagdish. Prerna? Jagdish ji said that just now that you almost conceded to his viewpoint. So what do you have to say to that?
Well, it's good to hear the viewpoints, and I think we're all learning in the process. I would just like to pitch in by a firm belief that if you look at the judiciary, you look at the judgments, you look at the law, you look at the acts, most of them are speaking about the confidentiality clauses, right? So when we talk about this entire gamut of places which I just mentioned, see, confidentiality is also, if you see, I think helping a lot in court. The kind of overload they have, this is something which is so unique to this process, which the parties would never ever find anywhere else. So when we talk about confidentiality, we also need to understand that unless it's waived by the parties or the law requires it to be disclosed, I mean, these are the aspects where it needs to, of course, be. This is, I personally feel that if the mediator has formed a good rapport with the parties, I think, and the confidence he's able to emanate, the parties will not get a better platform. Their reputation, their relationships will be most preserved if they use it to their advantage. And I also feel that more than anything else, when we talk about the faith and the trust aspect of confidentiality, can you even for a minute, I mean, it is something when, like, it's similar, not identical, but it's similar to what happens in a confession in front of a priest. So the party, whoever is confessing to the priest, feels very secure in that environment. So it is quite similar that the parties, if they are choosing mediation, this aspect not be ignored, but completely followed. And if, and of course, it's party centric, it's all about them ultimately. If used to their advantage, I think they would really, really benefit.
Let's see what
Thank
Janvi
you.
has to say. Janvi, so you agree that confidentiality is not a myth anymore, or do you still stick to your view that it is a
No,
myth?
I still stick to my view that it is a myth because I strongly believe that when you, as a mediator, when we are able to steer through the process, it is entirely in the hands of the mediator how, uh, you know, as Madam Prerna had just mentioned, rapport building, how well the mediator builds the rapport, how well the mediator is able to make the parties be at ease, and they're able to give out all the information regarding their matter, because at times confidentiality can pose a barrier in the process. It can come up as a big barrier because in as Prashant ji has just said that in order to in case of impasse, you said that confidentiality is required, but I say that in case of impasse, sometimes the need arises that if you are too confidential about some facts, then impasse can never be broken. To get over the impasse stage, the deadlock that we face, in order to break through it, we need to, you know, uh, move away from this confidential aspect and make it very transparent and make the and create an environment which is amiable, which is very convenient for them to open up and to place their views
Thank,
before the mediator.
thank you, Janvi. And
Thank you.
now would like to invite Ms. Chitra Narayan again, because the whole purpose of this debate is a brainstorming session for educational and improvement of our views, and would definitely want your take on it, please.
Thank you, Pooja. It's been a great discussion because I think the topic is, very absolute in its statement. And both teams needed to sort of draw from, this to say, take position either for or against. But I think this is a very layered and a very complex topic, which I think they've attempted to deal with in a very short time given. It is layered because I think first we need to identify what is this information that is confidential. Is it everything that is discussed in the mediation that is confidential? I think not. And I think our law has attempted to draw a balance between, this process as well as maintaining the sanctity of this process and maintaining transparency that Jagdish adverted to. So if one were to talk about transparency, we take the example of the government as a disputant. And if the government is a disputant, what happens to the public interest in knowing what the dispute was about? What happens to the public interest in knowing what the outcome of the dispute was? The second, so when you look at the law says that It is only proposals that are made, and it is admissions that are made, right? And it is acceptance of a particular proposal or making of a particular proposal that is protected by confidentiality. Likewise, our Indian Evidence Act also protects and keeps it as inadmissible information, discussions in settlement. But there are exceptions to this, and this is what I mean by a layered approach to this. The exceptions would be the kind of exceptions that Prashant spoke about, where there is an overriding public interest in letting this information be known for an overriding purpose, which could be the safety of children, as an example, which could be, you know, domestic violence that Prashant spoke about. So I think the point made by the persons who spoke for the proposition that the minute you have exceptions, there is no confidentiality. I think there is something to be drawn from that, and that is that we must balance this. If you have exceptions, these exceptions should be so of such an important or such a compelling nature that we carve out this exception to confidentiality, which the opponents spoke about as being the pillar of mediation. So there is a lot in this topic. This could go on for hours, and thank you everyone for bringing out these elements in this discussion.
Thank you, everyone, for taking out time from our busy schedules to be a part of this. Thank you.